From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Texas immigration law known as SB 4 goes into effect briefly after the Supreme Court declines to intervene before it's blocked again by a lower appeals court. Plus, Bernie Sanders introduces a bill to create a 32-hour work week with what he claims would be no loss of wages. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. A law last year that was passed and signed by Governor Greg Abbott called SB 4 creates a state crime for non-citizens to cross the border from Mexico into Texas and also allows state judges to issue orders requiring people to exit the country. This was blocked by a district court judge who said that Texas's citing clause of the Constitution as an invasion does not fly in this circumstance and that immigration is preempted by federal authority. And here is where the procedural tangles begin. The Fifth Circuit Court of Appeals issued a temporary administrative stay to put that lower court ruling on hold while it considered the issue. That meant the Texas law might go into effect at least for a time unless the Supreme Court intervened, which it declined to do on Tuesday. Let's start with a clip of Texas Governor Greg Abbott celebrating that decision by the Supreme Court.
What it signals is there are 6 votes on the Supreme Court that say it's okay for Texas to go ahead and begin enforcing the law. And so that's a very consequential step that's been taken. It's not conclusive, but it's consequential for now. First thing I'm going to do is get back and talk to the leaders of the Texas Department of Public Safety, leaders of the National Guard, as well as local law enforcement, and make sure we're all in sync together about exactly how this is going to be enforced.
Accompanying Governor Greg Abbott were countless headlines saying that the Texas law was going to be enforced. Lieutenant Governor Dan Patrick said that Texas would start making arrests of migrants. But Alicia, hours later, the Fifth Circuit waded back in and put this law on hold again while scheduling a hearing for today, this morning, on a more permanent stay of the lower court ruling. Alicia, what's going on here?
So we need to backtrack first and just discuss what this law would do, right? And this law would essentially make it a misdemeanor to cross the border into Texas under state law. And it's punishable by up to 6 months in jail. And those who repeatedly cross the border would be essentially prosecuted. That would be prosecuted as a felony and they could be deported. Essentially, make it a state crime, not just a federal crime, to cross illegally, and would allow the state to essentially also arrest migrants who come in. And this could include those who plan to claim asylum. This back and forth right now, or the last day or so, has been involving procedural issues and an administrative stay. And I disagree with the statement that we just heard. It's not really a victory for Texas. What the High Court really decided to say, well, we really don't want to rule on the emergency docket that people keep criticizing us for ruling on. We're going to let this play out. The Fifth Circuit merit panel is going to make a decision on whether to grant an emergency stay. And we're not going to intervene at this point in the dispute. But potentially, if this isn't resolved soon, at least that's what Amy Coney Barrett said in her concurrence, then maybe there will be an opportunity for the appellants, which is the Biden administration, to ask us again to intervene. But we're not going to get into this at this point.
To my eye, this is a dispute about process, as Alicia explains. And an administrative stay, it's important to understand, is generally not a stay that is issued with a view toward the merits. It's a judge or a court trying to preserve the status quo until they can have the time, have a moment to look at the issue and decide whether to issue a longer-term stay pending the broader appeal. And so here is a piece of the opinion by Justice Amy Coney Barrett, joined by Justice Brett Kavanaugh, explaining why they did not want the Supreme Court to intervene here. Justice Barrett writes, "So far as I know, this court has never reviewed the decision of a court of appeals to enter or not enter an administrative stay. I would not get into the business. When entered, an administrative stay is supposed to be a short-lived prelude to the main event. I think it's unwise to invite emergency litigation in this court about whether a court of appeals abused its discretion at this preliminary step." There were some dissenting justices, a more heated dissent issued by Justice Sonia Sotomayor, joined by Justice Jackson, and then a more tepid dissent from Justice Elena Kagan. Here is a piece of what she says. She says, I do not think the Fifth Circuit's use of an administrative stay rather than a stay pending appeal should matter. Administrative stays surely have their uses, but a court's unreasoned decision to impose one for more than a month rather than answer the stay pending appeal issue before it should not spell the difference between respecting and revoking long-settled immigration law. But Kim, what I think is also notable in this opinion from Justice Barrett and Justice Kavanaugh is they give an elbow to the Fifth Circuit. And they say that the lower appeals court should be able to take up this question about whether to keep the Texas law in effect or to keep it blocked while they are hearing the appeal pretty promptly. And it seems that the Fifth Circuit, or at least the panel that's assigned to this case, took the hint within a matter of hours.
Yeah, the way to read the Barrett-Kavanaugh written opinion here is exactly as you said, that they are focused on the correct issue at the moment, which is procedure. There is a difference between a temporary administrative stay issued in order to give a court more time to decide how they're going to handle this and whether or not they're going to issue a stay pending appeal, in which they really need to look at the merits of that decision. And this has all happened a bit in a rush. So what they're saying, essentially, the conservatives on the court are, hey, step back, let's give the court the time it needs to actually go through the issues here, rather than they're issuing something done in haste and rather are intervening before that process has been seen all the way through. I like it too, because it's in, I think, very stark contrast to the way everybody else is attempting to read this, whether it's Governor Abbott who's saying, hey, look, this high court said we have the green light to go ahead with this law. No, that was not what that opinion said at all. Or, the minority judges on the Supreme Court who were already using this as an opportunity to explain why this is such an egregious law and why it should be struck down before the Fifth Circuit has really had a chance to go through things itself. Yes, this opinion from Barrett and Kavanaugh did come with a little bit of a warning, which was, hey, we're going to give you some time to go through this procedure, okay, but get on with it. And also a little bit of a warning, which was, if you don't get on with it, we might indeed have to intervene. And so, yes, that was the Fifth Circuit responding to it. They very hurriedly arranged some oral arguments. They put a block back on the law while they're doing that. And hopefully this gets the lower courts back on track, doing the process all the way it's supposed to be done, which is what you would like to see the Supreme Court do and sort of ask the lower courts to do once in a while.
Alicia, what's your view when these courts eventually get to the merits? There is a landmark case in the Supreme Court, Arizona v. U.S. in 2012, blocking a law in Arizona trying to enforce immigration restrictions. And to my eye, at least some of what Texas is trying to do here is covered by that precedent. So I am skeptical that this law is eventually going to go into effect, because the idea that a state could order people to leave the country, that sure sounds like a matter of national immigration policy. And so if the Fifth Circuit comes to that conclusion as well, it's possible we might not even get a Supreme Court case on this. Maybe Texas is trying to reverse that precedent, trying to get the justices to reverse Arizona v. U.S., but it's also possible they could decide the Fifth Circuit had it right and not even take this case.
Right. So there are various ways that this case could go. Now, in Arizona v. U.S., which involved a very similar provision in the Arizona law that made it a crime to be unlawfully present in the U.S. The majority said, and it was a 6-2 majority, that Congress intended to preclude states from complementing federal law or enforcing additional or auxiliary regulations. Now, this kind of gets to an issue in the court's jurisprudence that involves preemption. And there are different kinds of preemption. There's conflict preemption, in which most justices are united in believing that when a state law directly conflicts with a federal law, that the federal law rules supreme under the supremacy clause. Now, there's another area called field preemption or implied preemption. where a state law may not directly conflict, but the federal government has regulated an area, such as immigration, has set forth a detailed scheme of regulating, and where states are implicitly preempted from regulating. Now, the conservatives on the court, I think, are actually very divided on this issue of implied preemption, and we've seen that in other cases that have come before the court in terms of like drug and FDA approvals and such, and states being able to regulate, or even uranium mining, for instance. So on the merits, I think the conservatives may be a little split, with Justice Gorsuch and Justice Thomas being a little more sympathetic to Texas's argument. But I think the problem here is that Texas's law actually directly conflicts with federal law insofar that it allows or makes it a state crime to be in Texas, even if you're someone who plans to claim asylum. And it also really undercuts another point that the Justice Department is making, is the federal government's and the administration's ability to manage foreign affairs and relationships with Mexico. Mexico has already said, well, we're not accepting anyone that Texas plans to send back. And this is going to create a real tension in terms of foreign relations. And I think Chief Justice Roberts in particular, but other justices, have been deferential to that claim by the federal government whenever it's come before the court.